Welcome to week 5 of evidence. This week we will continue our discussion of privileges with cases from your casebook on pages 615 to 667. The first case we discussed is In re Grand Jury Investigation. This is a United States Court of Appeals for the Third Circuit case from 1990. As background, a house had burned down from a fire that was potentially racially motivated. The couple living next door to the fire, along with their son and his fiancée, sought counseling from the parents' pastor. The son and his fiancée were not members of the church, but the son did sometimes attend church services. At issue was whether or not the family's conversation with the pastor was privileged. This court held that there is a clergy communicant privilege, and the court went on to define 3 aspects of the privilege. The court held that the communication must be made to a clergy person, in the clergy member's spiritual or professional capacity, and made with a reasonable expectation of privacy. This court held that on remand, the trial court would need to determine whether these second 2 factors were met, as the court held that the first factor had already been met. The next case is Evergreen Trading LLC v. United States. This is a United States Court of Federal Claims case from 2007. As background, we have an accountant, Cohen, who had provided advice relating to the plaintiff's investments. The plaintiff claimed that they were improperly penalized by the IRS for underpaying their taxes because of issues with their tax returns. At issue was whether or not the advice provided by Cohen was covered by an accountant-client privilege. This court held that the advice that Cohen had provided was not tax advice, and that Cohen was not acting as an intermediary between his client and an attorney. So therefore, the federal statute providing the privilege did not apply, and also the case law finding that an accountant can be an agent of an attorney did not apply. The next case is In re Grand Jury. This is a United States Court of Appeals for the Third Circuit from 1997. As background, there were 2 appeals that were being considered together. In one case, we had a father who had sought to avoid being called to testify about conversations with his 18-year-old son who was under criminal investigation. In the second case, there was a 16-year-old daughter who sought to avoid testifying against her father who was under investigation for an alleged kidnapping. At issue is whether or not there is a child-parent privilege. This court held that they did not recognize a parent-child privilege. The court found that many states don't recognize this privilege, only 4 states do, as opposed to other privileges that are recognized by a majority of states. When considering the public policy aspect, the court discussed the difference between professional relationships like attorneys, therapists, doctors, versus familial relationships, and ultimately held that a privilege should not apply to these family relationships. Our next case was Matter of Farber. This is a Supreme Court of New Jersey case from 1978. As background, the investigations of a reporter, Myron Farber, of the New York Times, had contributed to the prosecution of a defendant for murder. The defendant subpoenaed documents from Farber to examine. Farber then refused to comply, saying that the documents were privileged because they were from a confidential source. The court found Farber and the New York Times guilty of criminal contempt. At issue was, does the news reporter privilege stem from the First Amendment freedom of speech and press, like Farber claimed? And did it protect Farber from forced disclosure? This court held that no. The news reporter privilege recognized by some jurisdictions was not a universal privilege guaranteed by the First Amendment. Instead, the court noted that the defendant's Sixth Amendment right required that the properly subpoenaed documents be produced so that the defendant could prepare his defense. The court found that the defendant's constitutional Sixth Amendment right superseded Farber's rights to protect his source under that New Jersey Shield Law. Our next case is Peterson v. Bernardi. This is a United States District Court of the District of New Jersey case from 2009. As background, Peterson was imprisoned for 18 years for a crime he did not commit. When he was released, he sued for wrongful imprisonment. During the suit, the plaintiff realized he had inadvertently produced protected materials. He moved for an order compelling their return. At issue is whether the plaintiff's actions in producing the documents waived any of the privileges he might have had against inadvertent disclosure. The court held that the first step to determining inadvertent disclosure is determining whether the documents were originally privileged. Here, the court felt that the plaintiff had not met his burden in showing that the documents were privileged to begin with. Additionally, the court held that even if the plaintiff had met this burden, he did not meet the next step because he didn't adequately prove the documents were inadvertently produced. Next case is United States v. Reynolds. This is a Supreme Court case from 1953. As background, 3 civilians were killed in an Air Force plane crash on an experimental flight. The civilians' widows brought a suit against the government under the Federal Tort Claims Act, which waived the government's immunity to suits. The plaintiffs sought production of the Air Force's accident report. The government refused to produce the report, claiming the information was privileged because it contained information about equipment the government was experimenting with. The trial court compelled discovery, holding that the FTCA waived all privileges. The government refused, stating that they had contained military secrets that could not be disclosed. The judge then ordered the report produced for his inspection. Again, the government refused. The judge then ordered a finding for the plaintiffs on the issue of negligence because the government had refused the discovery order. The government then appealed this decision. At issue was, did the government make a valid claim of privilege to prevent the disclosure of the accident report? And the Supreme Court reversed, holding that yes, the applicable federal rules allowed for production of not privileged documents or information, and here that the government had made a valid claim of privilege. The next case is Jewell v. National Security Agency. This is a United States District Court for the Northern District of California from 2013. As background, we have a plaintiff who alleged that there was widespread eavesdropping by the NSA after 9/11, which violated their constitutional rights. At issue was, does the government have state secrets privilege, allowing them to not disclose information in the interests of national security? The court held that in this case, the privilege was properly invoked and that the subject matter of the suit constituted a state secret. Then the court held that regardless of privilege, the Foreign Intelligence Surveillance Act actually preempted the state's secrets privilege and also prevented disclosure. Our next case is United States v. Nixon. This is a Supreme Court case from 1974. As background, the plaintiff sought production of President Nixon's tapes and transcripts from certain meetings. The president claimed the tapes were confidential communications between his close advisors, and it would be inconsistent with public interest to produce them. At issue was, does the president have an absolute privilege so as to be able to perform his duties as president? The court denied this absolute privilege, finding that the district court's inspections of the tapes should be enough to protect the president. Our next case is United States v. Zanos. This is the United States Court of Appeals for the First Circuit case from 2006. As background, a state trooper had submitted an application for a warrant to search the defendant in connection with suspected bookmaking. The supporting affidavit relied on information provided by a confidential informant. Ultimately, the defendant was indicted on federal firearms charges. The defendant sought to suppress the affidavit, claiming the information included in it was false and that there was no informant, and then the trial court agreed. At issue was, did the trial court improperly suppress information from the affidavit and eliminate the government's privilege of confidential informants? The appellate court reversed, finding that the trial court did err in concluding that only 3 people could have possibly made gambling calls to the defendant, like he claimed, on the day in question. The court held that the trial judge, in refusing to hear the government's in-camera explanation of why it was a miscarriage of justice to disclose the informant's identity, had effectively eliminated the government's privilege. The court held that the privilege is not absolute, but does require a balancing test, and they found that here the defendant had a heavy burden that he did not meet. This next case is United States v. Moussaoui. This is United States Court of Appeals for the Fourth Circuit case from 2004. As background, our defendant was charged with crimes relating to 9/11. He contended that 3 depositions of Al-Qaeda members in custody of American Armed Forces would support his position that he was not involved in 9/11. The government refused to make these witnesses available for deposition, and the trial court felt that the depositions would be crucial to the defendant's defense, but refrained from dismissing the indictment. At issue is, when is a criminal defendant entitled to disclosure of classified information? This court held that some remedial measures were necessary for the defendant's defense, though the court also did not feel that dismissal of the indictment was necessary. The court held that the defendant is entitled to disclosure if he can show that the information is relevant and helpful to his defense, or essential to a fair determination of a cause. In this case, the court held that the defendant's rights were satisfied by the government providing extracts of summaries prepared by the government of statements by these 3 witnesses, rather than the depositions. And finally, we will end our reading with case book hypos 1 through 5 on page 666. Please be prepared to discuss these as a class.